of what stood out to them, questions that they had, concerns they have as they read SB 18, and how it might impact their family and their ability to parent their child with special needs. Below are a few of their questions, and I put them in categories. So the first was education. Could SB 18 be a vehicle to save school districts money on FAPE, free and appropriate public education, because anything that is not evidence or research-based would be categorized as not being an appropriate education. If SB 18 passes, is the parent no longer part of the IEP, individualized education program, process? And would the state then decide what is appropriate? Would procedural safeguards that are guaranteed under federal law, IDEA, and our state law no longer apply? What if they say only public school is appropriate setting for special needs kids? Could this mean no homeschool is allowed for special needs kids? Could this mean no private school is allowed for special needs kids? Could this mean no non-public school is allowed for special needs children? There is a Supreme Court decision whose verdict should come out this summer that potentially could impact the standing of SB 18 as well. It involves, it's a little complicated, essentially it's called merely D-, it's a legal phrase, or non-trivial. So essentially, does a school district need to provide those on an IEP with an education that's essentially equivalent to the basic floor of opportunity, or do they need to give maximum educational benefits? If the Supreme Court decides the basic floor of opportunity or merely D-, could SB 18 give school districts all the power to authorize only public education and leave parents of children on an IEP with no negotiating power? The other category is health that we're concerned with. Will specialized diets be deemed non-evidence-based? We have families who eat organic, non-GMO, paleo, GFCF, gluten-free, casein-free, specific carbohydrate diet, SCD, or GAPS. What if they don't approve our kids taking supplements, doing alternative medicine or homeopathic medicine? What if the state decrees children with certain diagnoses or developmental disabilities must have certain pharmaceutical interventions and treatments for their care? Will chiropractic care be deemed non-evidence-based? The reason why this question was brought forward is acupuncture was recently restored to the state budget of California for those that are on Medi-Cal or Medi-Cal managed plans, but not chiropractic. So we're kind of questioning why that was. What if a child has a medical condition involving a metabolic syndrome? Would the doctor report a parent to CPS because the child is overweight and they say the parents are not taking care of their child? Could potential, and this is a big one, and we're kind of seeing this happen all over the place, could potential medical kidnapping occur under SB 18? Example, you take a medically fragile child to the hospital. If you as a parent don't agree with the diagnosis, the medication, or the treatment, the state can intervene and take your child away. Could insurance companies deny services that are private pay for our special needs children? Another area of concern is safety. Will our kids be taken away because they have a tendency to wander or elope? A lot of children have done that, and the parents have tried all they can, and still that's happened. It's happened at school. It happened with Avante in New York. He wandered from school. Will they chip our kids without our consent? Developmental types of concerns. Will there be a cutoff age for toilet training of a special needs child? Oftentimes, many children, especially that are more severely impacted, those kinds of things are very difficult for them to accomplish. So it is a concern. Will there be a cutoff age for appropriately manipulating utensils for special needs children? Services that impact special needs community are IHSS or in-home supportive services, Social Security, Medi-Cal or Medi-Cal managed plans, regional center, at school district, Head Start. So the question is, will compliance of these, whatever the state standards are, be tied to the child receiving special needs, with the special needs receiving services? Something to keep in mind, both Democrats and Republicans in the state of California have a long history of creating legislation that has truly benefited the special needs community. Democrats currently have a majority. and in some cases, supermajority in our state. Because of the open-ended nature of SB 18 and its vague language, SB 18 is a dangerous bill for all families, including special needs families. I encourage you to bring forward this information to your legislator. If your legislator is either Republican or Democrat, it should certainly appeal to them in their self-interest, no matter their party. Please tell them to vote no on SB 18. And if you would like, our website is educateadvocate.org, and we have information there, and you can email us if you have other questions. Thank you very much.